My name is Nasser Eledrooos, and I'm a tech policy counsel at an American racial justice organization called Color of Change, and an Atlantic Fellow for Racial Equity at the Nelson Mandela Foundation and Columbia University. It's my honor to be facilitating and moderating this panel today. As we discuss the world of automated decision-making systems here at CPDP and elsewhere, we find ourselves wrestling with perplexing data issues. Systems around this space rely on sex and gender data to fuel complex algorithms with the stated goal of predicting outcomes on a population level. However, this practice surfaces a number of challenges, especially for transgender, non-binary, and gender-diverse communities. On one side of the coin, improved data collection, sharing, and usage about these marginalized communities can underscore prevalent discrimination, enhance healthcare accessibility, and uphold the dignity of every individual. But on the flip side, the concept of legibility carries inherent risks, suggesting that there might be a benefit in limiting the amount of information that the state and data collection companies know about those who are frequently stigmatized in society. Our panel today will delve into the legal and policy implications of gathering, distributing, and utilizing data on gender and sexual orientation across US, European, and global jurisdictions. Specifically, we'll be dissecting how the law, if at all possible, can maneuver through this intricate data maze. So let me introduce our panelists. Sitting to my left is Ezra Waldman. He's a professor of law and computer science and faculty director of the Center for Law, Information, and Creativity at Northeastern University School of Law in Boston. He researches the ways in which law and technology reify traditional structures of power with particular focus on privacy, misinformation, and the LGBTQ community. He has written 2 books and published nearly 30 scholarly articles in leading law reviews and peer-reviewed journals. Ari uses he or they pronouns. Sitting to the left of Ari is Kevin Guyan. Kevin is a researcher and writer whose work explores the intersection of data and identity. He's the author of Queer Data, Using Gender, Sex, and Sexuality Data for Action, which examines the collection, analysis, and use of gender, sex, and sexuality data, particularly as it relates to the LGBTQ people in the United Kingdom. Kevin is a research fellow in the School of Culture and Creative Arts at the University of Glasgow and a member of the Royal Society of Edinburgh's Young Academy of Scotland. He sits on the Young Scots Data Advisor Group and the boards of Evaluation, Support Scotland, and the Equality Network. Kevin uses he or him pronouns. Joining us on Zoom is Oskis, who's a PhD candidate at the University of Washington. Their work focuses on questions of power and technoscience with a particular emphasis on the intersection of gender, disability, race, and artificial intelligence. They are an inaugural Ada Lovelace Fellow. Oz uses they or them pronouns. Thank you all for joining me today. The structure will be for each of our panelists to present their work for about 7 to 10 minutes. We'll go into a little bit of a discussion, and then we'll take some questions. Ari, first to you. Or excuse me, Kevin, first to you. And if we can have the slides up, please.
Perfect. Great. So thank you, Nasser, for that introduction, and it's really kind of lovely to be here with you all today. So one of the questions I'm really keen to explore in our panel today is who benefits and who loses when we collect, share, and use gender data? And how might collecting more and more gender data push bigger ambitions about justice and liberation for minoritized communities further into the distance? So I'm based in Scotland, in the UK, and I want to kick off by sharing some recent data developments of things happening in the past few years on this topic. On the 17th of January 2023, the UK government enacted previously unused powers and overruled a bill passed by the Scottish Parliament. This bill was intended to introduce a self-identification model for how trans people change the sex marker on their birth certificate. The following night, around 500 protesters gathered outside 10 Downing Street to express their outrage. Among a sea of trans people and their allies, one person held a large white placard with "Death to Admin" written in black marker pen. So for me, the seemingly mundane topic of administrative systems and how they record LGBTQ lives has become a key frontier in the fight for equalities. In the UK, a situation now exists where systems either need to adapt to reflect an always changing world, or LGBTQ people need to modify themselves to match the expectations of these long established systems. Now, the categorization and counting of trans lives is part of a bigger ongoing expansion of data projects to include previously excluded communities. Most notably, the addition of new census questions on sexual orientation and transgender identity to UK national censuses conducted in 2021 and 2022. Yet, the inclusive addition of these new questions to quantify the size of the LGBTQ population occurred alongside other changes to census questions on sex, which, following the efforts of anti-trans campaign groups, were reframed to exclude many trans individuals. So across the design and operation of many data systems, LGBTQ lives and experiences are not universally excluded. In fact, in the UK, they are more visible than ever before. But, as I'm sure we'll explore in our panel today, this inclusion is only partial. While some lives and experiences are brought into the fold, others remain situated outside the system. So in these examples and many other cases that involve the collection, analysis, and use of gender data, it's helpful for us to think about what's considered to be the problem. Now, most often, the problem is identified as the misrecognition of minoritized communities. So in other words, data systems are not accurate enough, they're not detailed enough, or there is some error or oversight in their design. This understanding of the problem makes sense. Misrecognition aligns with kind of common sense assumptions about what identities are, and that might be identities as something fixed in time and space. The assumption identity is independent of the outside world. Identities as something real or some kind of ontological truth. Identities as interoperable, working across different systems, as something pure and uncontaminated. And lastly, identity is something people can and should disclose. So I want to draw particular attention to this last bullet point and the question of disclosure, and ask if you need to be out to be counted as a valid item in data collection activities. Data systems force LGBTQ+ individuals to change aspects of themselves in order to gain access. We can imagine this as a form of conditional hospitality. For example, many systems only make sense of LGBTQ individuals that are out. So an open declaration of sexuality and/or gender identity has become part of the price of entry. So while this requirement might seem progressive, outness is not desirable or possible for everyone, and tends to benefit individuals who are already closest to the ideal of full equality. My point here is that the collection of LGBTQ data too often fails to recognize that in the design of the tools we use, they only count queer individuals who are out. So this kind of uncritical account of disclosure and being out has appeared in a few new, interesting ways in the UK. Mindful that not all staff are out in the workplace, some companies have established targets to increase the proportion of out LGBTQ employees, numerical figures against which success is measured. For example, as I've shared on the screen, the BBC has new diversity targets for its number of LGBTQ+ staff, and this has evolved into an outness metric where it aims for more than 50% of its LGBTQ staff to be out at work. Now, while it might seem progressive, in my view, this metric is misguided and advances an assumption that all employees should be out in all situations, and that bringing your whole self to work is the best option for everyone. This blanket view fails to consider different vulnerabilities, cements a kind of linear notion of change, and places too much emphasis on visibility. But returning to my original question, what if misrecognition is not the problem? Perhaps data systems are not misrecognizing communities, but are functioning exactly as designed. So an area of interest for me at the moment, and hopefully we'll have a chance to speak about this during our discussion, is what happens when we flip the question. Rather than ask, do data systems reflect and record the world around us? I'm intrigued and interested in asking whether or not data systems shape how we understand identity and what we do based on that understanding. So this kind of idea about data systems as being generative or productive is informed by some amazing work from scholars including Susan Stryker, Paisley Curra, and Dean Spade, a quote from whom I've shared on the screen. So I want us to think about how data systems play a key role in authorizing the existence of different identity groups, whether it's options presented in a drop-down menu on a website or the boxes you can pick from in a census. Data practices can be understood as something generative, so they don't just describe the world, but they bring certain things into being. I share these examples here to underscore how the inclusion of some LGBTQ people is not a straightforward success story, as some might believe. In the case of the UK census, the quantitative veneer of this data exercise masked many design decisions that shine a spotlight on some communities that kind of meet the requirements of the system, while pushing others who fall outside those requirements further into the shadows. So in the context of the UK, although the census did count those who are lesbian, gay, bisexual, and trans, it continues to exclude many individuals who sit under the LGBTQ+ umbrella, most notably non-binary people. My point here is that adding a greater diversity of people into a data system is not the same as querying a system, reviewing its rules and regulations, locating what is broken, and discarding the parts that remain beyond repair. So to kind of bring my opening remarks to a conclusion, what I want us to think about here is to assess whether our efforts to repair or fix systems that collect, analyze, and use gender data is really the best use of our limited time, energy, and resources. We must also ask that thorny question whether all systems are in fact worth saving. What if we come to realize that systems have inequality and exploitation baked into their design, and that no matter how hard we try, they cannot be fixed to build a better world for everyone? So I'm sure these are themes we'll pick up in our discussion, and I look forward to exploring them all in more detail.
Thank you. All right, next we'll have Oskies, who is joining us again via Zoom, who will share their opening remarks.
Thank you. Can everyone hear me okay?
Make it a little louder.
A little louder, please.
Let me see.
I think you're good. You're good. That was on our end. Yeah.
Okay, it's all good. Thank you for having me. I am deeply amused by the range of accents and geographies at display here. I'm speaking with a British accent from the United States. Then you have Kevin, then you have Ari, then you have Nasser. Anyway, so thank you for having me. And yeah, thank you, Kevin, for your comments. They neatly dovetail into mine, which are largely about me doing that obnoxious philosopher thing of, instead of answering that baseline question of, should we collect or not collect, instead challenging the question itself as a way of getting out of answering it. So the framing of, do we collect this data or not, do we trust this or not, is something that is pretty pretty common and seems to follow pretty logically from how we tend to talk about data and data collection, right? Which is particularly, but not exclusively in an American context, but in a European one as well. I heard some of that in the panel before this one, is imagining it as this kind of contractual procedural relationship. We imagine that data collection and participation in data collection are built around a sort of single binary decision. You either agree or disagree with the data's collection and uptake and disclosure. But if you look at the way that people reason about data and the harms it can do, and if you look at the way that people, just think about disclosure in general, the sufficiency of this logic quickly breaks down. A contractual view kind of imagines data as a two-party system, right? There is the data subject, the person who gives up the data or releases the data or trusts the data collector, who is the person who takes it in and uses it. But in practice, there are many more parties on both sides. On the sides of data collectors, it's rare for any system of data collection to not involve intermediaries, and in many cases involve other entities using the data once it is collected, right? If anything, the big push for open data in the UK in the early 2000s was very much based on this idea of, once we collect it for purpose A, we can use it for purposes B, C, D, and E. And on the other side, the data that is collected is very rarely of use or collected because it is about or only consequential for the actual data subject, the person giving it up, right? So to use Kevin's example of the census, we don't collect individual people's gender or sexuality because we care about that individual person's gender or sexuality. We do it because, as he said, we care about these big population level inferences. In other words, what we are trying to do with government data collection in much the same way, as much as I think that people working for state administrations would hate this comparison, in much the same way that marketers do, we are trying to take information about the people we can see and use it to infer things about the people we can't, who are in some way in association with the ones we've collected data about. And what this means is that the decision of whether to give up data or not, whether to trust or not, is always a very fractious and fractured and uncertain decision. The person who is giving consent is really speaking for, in terms of where the harms fall, more than just themselves. And the person that they are giving consent to might be repurposing that data in 30 different ways. So a simple decide to collect or not to collect approach ends up being largely insufficient. In fact, in some ways you could say it's actively damaging because it obscures these more complex imaginaries of how data collection works, how data is used, and also what the relationship between the subjects of data and administrative bodies should or could be. So instead, to me, the best way of thinking about this is a relational approach, one that's been heavily influenced by the work of Ari, by the work of Salome Vijun, by the work of several others, where we don't just say, okay, do we collect data or not, or do we give up our data or not, as a one-off decision, but instead understand that data collection and data, I need a better word than giving up, data release, say, is actually the creation of, in an ideal universe, an ongoing relationship between a shifting array of data subjects and data collectors, processors, and users. A big source of inspiration for how to think about this, and something that I would encourage people to look into if any of this is grabbing you, is the indigenous anthropology of a scholar called Audra Simpson, who looks at how Haudenosaunee people in North America viewed and still view the treaties that governed, access to land and the colonization process in the United States and Canada. The colonists took this approach that is very familiar, right? It's a contract. We're making a deal between your group of people and our group of people about who has this land, and we sign it, and then we go away and we take the land, and that's it. That's everything. But from a Haudenosaunee perspective, there's no such thing as a simple one-off decision around giving things up, because whenever you make any decisions about access or about trust, and ultimately contracts are about trust, there are going to be consequences that you cannot foresee at the time. There will be future generations whose lives are impacted by the decisions you've made. They should have the right to intervene in the process, even if it's after the fact. There are going to be third-party consequences or vicarious and external impacts of the decision that you've made that won't be visible at the time and need to be made, that need to be addressable when they become apparent. And so from a Haudenosaunee perspective, the treaties were not an agreement over land, but instead an agreement to enter an ongoing relationship, one in which when new things were discovered, when new consequences occurred, when new uses occurred, when new voices became relevant to the conversation, there would be a revisiting of the deal and an adjustment of it. And the point here is to say that I think a similar approach, an approach that sees this question of collect or don't collect, trust or don't trust, as an ongoing relationship, as something that inherently, whether it's, capital B, capital D, big data, or even just more conventional and traditional pen and paper surveys, that sees it as invariably involving questions that you can't know the answer to, or in some cases even ask at the time that you first consent, and parties who may not be alive at the time when the data is collected, that see it instead as an ongoing negotiation, one that continues for the life of the data, and that should occur or be revisited when that data is put to new uses or comes to involve new parties. So rather than simply focus on collect or don't collect, or trust or don't trust, the question becomes instead, trusted by whom, for what, and when, and where? And those are questions that should be revisited every time the answers might be different. The only, other thing I'd add, and this is, it follows, but it's also slightly in continuation of Kevin's comments, is to say that I think we should also be thoughtful about the way that data needs to be regulated, because it is powerful and is used and and clearly the existing approach is not working and we need to take a new one. But also that simply participating in this sort of blind, well, collection is good and therefore go for it, or collection is bad and therefore don't, obscures the fact that the actual role that data plays in decision-making is far more strategic and brittle than I think we often explicitly discuss when we're talking about, the age of big data. To use Kevin's example of healthcare, right? It's fair to say, and I'm guessing Kevin would agree with this, that the relevance of the data that is being collected by the UK government around, say, the number of trans people to the provision of trans healthcare in the country is not immediately apparent based on their public statements or actions or motivations or reality. And I think that one thing we have to be cautious about, and one of the reasons to take this relational approach that says, okay, let's look at unfolding consequences as well as just what intentions people say they have at the time, is the fact that a lot of the time data can serve as an excuse or justification rather than a rationale. And that the ability to claw that back, to shift the power balance somewhat, particularly for marginalized groups, is deeply important. And it's precisely because of the imbalance in knowledge, not something that we can do ahead of time. It's something that requires a much more direct a much more participatory approach to understanding how data unfolds in practice.
Thank you. Next, Ari.
Thanks so much. Thanks to everyone for being here. Before I start my remarks, I just want to encourage everyone to buy Kevin's book, Queer Data, and also thank Oz for signing in. I believe it's the middle of the night, the small hours where they are, and also to explain to the audience that one of the reasons why Oz can't be here in person is they have an interview for a faculty position, and I think that's probably the best excuse for not being here in person, so good luck. Good luck on that, and thanks, Nasser, for the great introduction. So my short remarks at the beginning of this panel dovetail very nicely with what we discussed so far, and I want to focus on, as Kevin noted, the nature of the data system, but I want to focus on it from a legal standpoint, particularly how the law creates this legal system. And I'll focus on two implications. One, that the data ecosystem, particularly when it comes to gender and sexual orientation data, is created, at least in the United States, and I'm sure quite elsewhere, with some other goal, other than what we generally would assume a data ecosystem about gender would be about. We might, as we've said in this panel already, think that, oh, it's to make, the data ecosystem has been created by law to understand or make population level conclusions about people. No, that's not actually the case. My research, which is based on public records requests to how states collect this information, interviews with civil servants who develop these forms, interviews with regulators and policymakers, and also speaking with people on the ground, including physicians who fill out forms that have data, with trans and non-binary people who have these experiences, is that this system is built not for trans or even cisgender people to understand gender, it's built for the state to run efficiently. But not only is the law built for the state to run efficiently, that system, once you investigate it, is also inexplicably organized. It's ridiculous once you pull up the hood and look underneath it, how it works. And those are the two conclusions that I want to mainly talk about today, and that's the result of what I see in the world. So how do I come to those conclusions? Well, this way. Despite the fact that forms, when a form that a doctor fills out, an application form, a communicable disease reporting form, a application for benefits, despite the fact that these forms are often required by statute, written and developed actually by civil servants with discretion, they are key elements in what Laurel Westbrook and Kristen Schultz have called the social process of determining gender, because they list questions, they give you only a certain set of answers, sometimes they're required, sometimes they're not required, and that not only affects and has implications for the individual person about whom the form is written, like the patient or the applicant, but it also affects how everyone else, how the doctor, how the civil servant, how the system itself understands gender. Because what the law does from every step of the way, the law requires collection, and then there's a civil servant who designs these forms. The law requires pooling and sharing of data. There are statutes on the books in every single state in the United States that requires agencies to share data, including sex and gender data, with other agencies, with the federal government. And there are also statutes that say you can share them if you want. And these sharing agreements, which are essentially contracts between agencies, are incredibly frequent. There is a single agency, just as one example, there's a single agency in the very problematic state of Florida that is right now in a party to 1,172 gender data sharing agreements. That's just one agency. Now, not every agency is a party to that many agreements, but there are hundreds of agencies in every state. There are 50 states. Like, we're talking the sharing of terabytes of data about individuals. And that information is pooled and used for various purposes, whether it's securitizing to determine you are who you say you are, and so forth. But at every step of the way, law is not only requiring or enabling this, law is also insulating this process from interrogation and change. And although there are lots of discussion and lots of things about this panel that may be controversial, especially in Europe, but one of the key tools that insulates this process from change is data protection law. Data protection law increasingly is a process-oriented, as I've written quite a bit about, it's increasingly a process-oriented law that requires things like an impact assessment or requires procedural protections around the collection and use of data. But when those processes, and every state in the United States has to complete an impact assessment, when it procures a privacy impact assessment, when it procures new technology that uses demographic, or in this case, sex and gender data, those impact assessments have been reduced to mere checkboxes that simply say, does this new technology collect and use gender data? And then you check off yes. And then the next question is the data sensitive? And you check off yes, gender is considered sensitive data. And then that's it. The only thing that the impact assessment focuses on is security of the data. It doesn't focus on why you're using it, how you're using it, how you ask for it, how and when it's being pooled with other information. As a result, because all you need is to complete this impact assessment for the technology, the algorithm that you procured from an independent for-profit company, because all you need is this procurement contract and this impact assessment, it prevents advocates, it prevents regulators from interrogating how this information is being used. And that's also where you see how ridiculous and almost Kafkaesque this system really is. Because when you talk to regulators and when you talk to civil servants about why they're collecting this information for a particular purpose, in the state of Idaho, for example, you need to provide your sex in order to get a fish or wildlife license. In various states, you need to provide your gender with only a couple of options in order to apply for healthcare benefits, right? There are lots of different contexts where you need to provide this information, but when you ask people, the most common responses are things like, I have no idea why we collect information, why we collect gender information for that reason, on this form. Or, it's always been done like that, and the person who wrote this form no longer works here. We want it because we want to ensure you are who you say you are, even though there may be a gazillion other better ways to determine that this applicant is the actual person. There are layers and layers of inanity in the process of how we collect, use, and share data. But in that inanity, there are harms and there are concerns, and I'll finish with just one of them. The latest literature in this space has spoken about how, although some people argue that the government should get out of the business of collecting gender and sexual orientation data entirely, with reason, the state has used this information in service of white supremacy and homophobia and transphobia before, and bureaucracies of violence don't need more data to make us more legible. But there are a lot of scholars, Jessica Clark, for example, at Vanderbilt, Plaisley Curra, who Kevin mentioned before, who think that there are benefits to collecting some data in some contexts, benefits in other contexts, different types of questions you might ask in different contexts, and then some contexts where it's not valuable at all. That may make sense to a lot of us, but the problem is none of that data is siloed today. All of that data is pooled together and used by data matching or data mining systems in these securitizing roles, meaning that if a fusion center or if a data collection, if an agency that has contracts with all of these other agencies to collect information about their residents and citizens has now collected information, gender information, where questions about your sex and gender look different on every single agency's forms, maybe that information was useful or not useful for those particular agencies, but within that agency. But once they're pooled together, all of a sudden, trans people, non-binary people, gender-nonconforming people now have conflicting answers. On one form, they listed their sex was male. On another form, they listed that their gender was non-binary because maybe their assigned gender at birth was male, right? But their gender is non-binary. All of a sudden, these conflicting answers are now going to flag you as a fraud. And that has happened to, not only does it happen to a lot of people all the time, not just for gender, but in my research, I've already interviewed over 100 people who have been denied government benefits because their sex and gender data on pooled information conflict. So that means that we have to reassess the paradigm of how we think government should collect information. One single question across every agency for every single purpose, that doesn't make any sense. Not collecting information, well, there's strong arguments in favor of that, but that also might mean that people don't get the right health care, or we can't highlight discrimination if you're not collecting information about people. Different questions in different contexts, that means that artificial intelligence and algorithms are gonna flag you as a fraud when you apply for benefits. So we now collectively have to figure out a new way of dealing with sex and gender data that can make minoritized populations more legible in this new era of AI.
Thank you very much, Ari. So I'd love to kick off this discussion. We've talked a little bit about this sort of paradigm of like collecting or not collecting. Often I think about those who don't really have a choice and of whom data is already collected about them. And particularly, given that I have a lot of experience with the American justice system, I think sort of when we think about administrative and discretionary law, I think about that context explicitly. Recent research from the American Journal of Public Health and UCLA Law indicates that, around 40% of the people incarcerated in women's detention facilities are LGBTQ, compared to 3.5% of the general population within the US. And we know that there's tools in the US justice system that algorithmic decision-making tools such as risk assessments that determine whether people will be eligible for parole, and they incorporate gender or sex-related data in this way. This is for the panel, but how do you navigate issues of legibility and the authority of the state directly within institutions of harm or systems of power where the person who has no choice in their information and their data being collected, their very existence is dependent on some form of information existing at all? Open question.
Sure, I'll kick it off. Oz has actually done some work on this, so I'm looking forward to or done some work related to this. So I'm looking forward to their response as well. This is absolutely right. I'm thinking also of Kiara Bridges' work on the poverty of privacy rights, where she talks about how Black women who are on public assistance are often required in order to get the benefits that they are entitled to, they have to constantly provide more information to the government. And many people of privilege are able to exempt themselves from this situation because they don't need as much on a daily basis from the state. So this question, I think, is a great question because it highlights not just the dilemma about collect or not collect, but when we do collect, it affects certain people more than others. And I think that is one of the main reasons why there are lots of scholars and advocates who feel that the government should be out of the business of collecting data entirely. And I know that both advocacy organizations and the government in New Zealand, for example, advocacy organizations throughout Europe have come out with white papers and specific legislation for eliminating this kind of information. And I don't know the answer, but I still worry about if we eliminate the collection of this information entirely, that can address one problem, but then it creates another form of erasure by saying, like, if we don't know about X and Y piece of information, we're not going to be able to enforce our human rights or our discrimination law. So then that means that if we allow the collection in certain contexts, will that mean that discrimination law then becomes only available to the privileged? Right? So because they're the ones not as harmed by the collection in the first place, the other people, not only the incarcerated people, trans people who aren't incarcerated, are also wrapped up into the carceral system simply by being stopped for walking while trans, and they're just harassed, right? And people who, I mean, in the United States, there are 1.7 million queer people who are on Medicaid, people who can't afford health care in a country as backward as the United States that doesn't provide healthcare to its people, are going to be wrapped up into the system as well and are going to be denied services, right? And then I think about the information in the hands of another Trump administration. So I constantly go back and forth on this, but I think one of the things that we need to do, if we're going to go in a context by context way, we need to think about three things. We need to think first about whether we need this information for a particular purpose. If you only need it just to determine you are who you say you are, there are tons of other ways to do it. But sometimes, like in the healthcare context, there are reasons why you want to know a sex, or some reason why you want to know sex, and some actually you want to know gender. And that's the second question. If we need this information, which information, right? There may be benefits to knowing someone's assigned sex at birth, and then for certain health conditions or for certain other purposes, we don't need sex, we need gender. And then if you determine the right one that you need, then the third final principle that civil servants should consider is an anti-subordination principle, that we should collect it in a way that serves the communities that are going to be most harmed. And I have in fact seen that in agencies in the United States that focus on sexually transmitted infections and HIV, right? Because in the United States, we have health departments in the states are essentially big reporting organizations. They just report incidents of diseases to the CDC. And they do other things, but that's a lot of what they do. And they have individual offices, like for tuberculosis and for and other things. And then they always have an office for STIs, HPV, hepatitis, and HIV. And their forms and their processes and their understanding of sex and the harm that can come from sex and gender, data collection and legibility are so much more advanced because since the 80s, the queer community has been a key stakeholder in these departments, right, since the AIDS crisis. The queer community has not been a key stakeholder in other departments. So that is a roadmap for how to do this better. It's not easy and it doesn't work tomorrow, but it's a roadmap.
No, that's great. Oz, I wasn't sure if you wanted to jump in on that. No worries if you're not feeling that.
I mean, I do now feel like it's like I've been kind of hyped up. I don't have that much interesting stuff to say here, I don't think. I guess I'd open by both thanking and then cursing Ari for making me just order another book as we spoke. It's going, oh, that sounds really useful for a book chapter I'm writing right now. And there goes my budget for the month. Yeah, I think this question of, like, the questions that Ari raises are deeply important. And I think that in the context of your concerns around, things like the carceral state, we might add like two subsidiary questions, which is, what are the consequences of data collection and how closely tied do those consequences actually have to be to the collection of the data? So I'll give an example. If you are in prison in the United States and you are seeking access to trans medical care, well, then as a long series of judicial precedent suggests, you're shit out of luck. But in the unlikely event you're not shit out of luck, you obviously have to disclose, right? You have to disclose that you are trans. And if you do this, then one thing that is pretty common is that the prison will then go, oh, well, you're a vulnerable population. Like, who knows what might happen to you in general population. So for your own safety, as a result of you requesting medication, we're going to put you in solitary confinement for the rest of your sentence. For anyone who hasn't looked at the actual consequences of solitary confinement, the idea that solitary confinement would be the solution to the fear that someone might experience harm in prison is somewhere between unintentionally funny and deeply offensive. Solitary confinement is essentially the best way to guarantee that someone leaves on a stretcher instead of, on their feet. And I think one of the things I want to pull out here is just that issue of, as Ari raised, for what purpose are we collecting this data? Is there really any reason to say that the decision to go into solitary confinement because someone might be at risk of harm is not their decision to make, for example. Is there any reason to say that people seeking medication in prison should have to, do that particular calculus? I don't think that there is a good form of prison to be in. I'm opposed to the carceral state, both in general and in the case of the United States in particular. But if we're talking in terms of harm mitigation, in terms of anti-subordination work, I think it's fair to say that asking these questions about how we detach data collection from their consequences is pretty crucial here. And a lot of the time, as in these cases, once you think about it, once you avoid the mental trap of saying, well, the policy is the policy, once you think about, okay, but does it have to be the policy? It becomes pretty clear that there is really no reason for these things to be connected to each other whatsoever. That quite a few of the harms that are done with data in these environments, the question of consent being like a much more complex one, are at best unnecessary and at worst malicious. And so some of the solutions here are complicated, but some of them are honestly very simple. And they're less to do with the intricacies of data and more to do with the way that once someone is in a jumpsuit, we treat them as a non-agentic creature with no personhood, no rights, and no power to decide over the shape of their own life.
Thank you. Just before we move to the next question, I just wanted to point out that there's a microphone there. So if you have any questions that you would like to ask the panel, please don't hesitate. You walk up, I'll call on you, and we'll see what our panelists have to say. Kevin, I wanted to pivot to you and ask about in circumstances where data is collected, we're talking explicitly about the United Kingdom census for 2021 and 2022 that captured data about people and their sexual orientation, gender identity, as well as whether they identified as transgender. You outlined sort of the structure of how that appeared in practice, and I guess I'm wondering, within this structure, what did legibility look like? Who was still potentially excluded? And I think about that, I guess because I'm American, in the context of race, right? In the United States, in the US Census, if you're not familiar, we have a bizarre taxonomy of different racial categories. I identify as South Asian and of the Middle East, neither of which appear on these categories. And so, pivoting back to the census, I'm curious where you find legibility to be effective and not.
Yeah, I can, my personal passion, the census, I can speak to that. So some of the research I did around the census in Scotland in particular was, I think, similar to Ari's work, kind of engaging with decision makers, civil servants, looking at the paper trail of decisions made, and really trying to expose that kind of quantitative veneer of a census. So this kind of large population exercise has an assumption of being a kind of gold standard. It's often used as a benchmark for many other kind of diversity monitoring exercises across the public sector, private sector, and charities. So for me, the kind of questions that were selected, the response options that were designed, trying to expose the kind of subjectivity and the decisions around those possibilities. One example being, in particular in Scotland, the committee who were responsible for kind of working closely with the National Stats Organisation to kind of select these questions. And for me, I was alarmed to discover that these politicians, their knowledge around gender, sex, and sexuality and data was patchy, slim to nil in some places, yet they were in positions of power to be making the call as to who's in and to who's out. Some of these kind of differences appear across the UK, so there are different questions around capturing the size of the trans population in England, in Scotland, and in Northern Ireland, which actually doesn't ask that question at all. So really following this kind of paper trail for me was interesting to see kind of which identities were understood as worthy of inclusion, and which identities were also, in a way, unfathomable. Some kind of sexual orientations, some gender identities, which decision makers would openly ridicule, openly belittle as something that doesn't really exist. We can't ask about that in a census. So actually going into the kind of decision-making process exposes who in the eyes of the state is seen as kind of worthy of being included. And in the context of the UK, which has a census every 10 years, we kind of see this chart of progress. So we added a question on race, and then 20 years ago we had a question on religion, and now is the kind of the moment of sexual orientation and transgender identity. So again, this kind of expanding inclusiveness of the state. But I think what's also interesting is in this moment of high inclusion and high visibility, we're also pushing a lot of the larger, the wider LGBTQ plus umbrella further into shadows. So the UK census is one of the most inclusive censuses in the world in terms of this, but it doesn't meaningfully count non-binary people who have to select male or female in a compulsory question. So again, this push and pull between inclusion and exclusion, I think, is really important when we look at something like a census and that idea of who is legible in the eyes of the state.
Thank you. We have 2 questions, I believe, if you'd like to share. I don't think the audience microphone's on.
Hello? Hi. Thank you. My name is Sofia Ignatidou, and I'm leading on AI policy for the ICO, the UK Data Protection Authority. I found the conversation really interesting, and especially the question around to what extent you create additional risks to individuals by collecting more and more sensitive data. And I think that's why principles in data protections in GDPR, like purpose limitation, data minimization, are really crucial, and that's something we try to highlight in guidance we produced recently. But the question I have for the panel is, because in the context of processing special category data and sensitive data for bias mitigation, this is a really live debate right now. And one of the ideas that have been proposed is because organizations do acknowledge people are less likely to offer sensitive data. So the idea of actually inferring proxies, so basically using proxies to test for bias, is something that has been proposed. So basically organization inferring people's sexual orientation or gender reassignment. Do you feel that is like a solution around the problem of mitigating bias without explicitly asking for that data? Thank you.
Thank you.
I'll try and speak to that very, very briefly. Can everyone hear me okay? A really interesting question. Thank you for that. And I think quite problematic in some ways as well. So it raised a few questions for me. Firstly, around this kind of assumption I come across, particularly in kind of private sector companies, around people's reluctance to share data about gender, sex, and sexuality. That's nothing that I've actually come across in my work. It's not something that's actually backed up by evidence in many cases. And when asked the right type of question in the right type of format, and it's explained why the question is being asked, people are generally happy to share information about their sexual orientation and their gender identity. And we saw that with a large response rate to the questions in the census. In terms of proxy data, for me, this is really interesting, particularly around questions on same-sex relationships. So I mentioned, yes, it's this landmark moment for sexual orientation and gender identity data, but censuses around the world do ask questions on the composition of households, and within households, kind of providing opportunities for people to out themselves as being in a same-sex relationship within a household. But again, for me, this is really problematic as a proxy because it's bringing into the foreground certain queers who are coupled, who are in monogamous relationships, and again, pushing those who maybe don't fit these kind of heteronormative assumptions further into the shadows. So I think my point around proxies is think, if we are using a proxy, who is being foregrounded in that decision?
I think that's incredibly important. Very briefly, I'd add if the problem, there are lots of problems with using sex and gender data, but if the problem is the power political decisions, or the power dynamics in using those questions and who would answer and how they would answer, there are similar power dynamics and normative questions and political decisions being made when you decide what will stand in for sex and gender. So I recommend this book, The Science of Standing In. It's all about proxies, which discusses, the author's name is escaping me at the moment, but it discusses this whole process about how proxies for data or things that we don't necessarily think we should collect, or in this case data, still replicate the same problematic decision-making systems and still replicate the biases in the social context that you would collect the data in the first place. So I'd be concerned about simply using proxies because of the replication problems.
Do you want to jump in?
Yes. The author is Dylan Mulvin, by the way. It's a great book. I'm happy to finally meet someone who recommends books as often as I do. I fully agree with both Kevin and Ari's points here, I think, about who becomes visible and the power angle. In fact, I'd say that if I've learned one thing from living in the US, well, okay, if I've learned one thing from living in the US, it's don't. But if I've learned two things from living in the US, then the other one is that a lot of the time proxies don't so much eliminate power as they do diffuse it and make it harder to combat. In the same way that the difference between dog whistle politics and overt racism or transphobia or homophobia is often that combating it feels more like punching fog. You have to explain to people why it matters and so on and so forth, as opposed to sort of just outright, well, if you're going to hate us, then at least say so. A lot of the time, proxies, when they do cause problems, can actually be harder to dispute and address because there's more explanatory work required. It feels more detached. Exactly the things that make it attractive from a collection point of view also undermine the ability of data subjects to challenge them. And then the other angle on it, and I think that Ari and Kevin both kind of touched on this in a way, but I think it's worth emphasizing, is not just who becomes legible through these proxies, because a proxy for sexuality or gender implies that you have decided, you have identified components of social and cultural life that are represented in, say, the census, that are meaningfully and uniformly or largely uniformly distinct between different populations. There's also the question of how this can become a self-fulfilling prophecy and kind of circular. And so a brief story on the history of trans healthcare, which I'm currently writing a book on and have done too many interviews for. In the 1950s through to about 1980 or so, the agreed upon wisdom in all of medicine, law, science, social science, and everything else is that all trans people were heterosexual. Every trans person I've ever told this to find this deeply funny. The reason for it comes from a book in 1966 that was the first book on trans people to be published for a professional to scientific audience, where a lot of people adjusted their narratives to tell this story of heterosexual person unfortunately waylaid by a fluke of biology because it made for greater social acceptance. And so all of the doctors who began providing medical treatment and trying to diagnose people had this book as basically their Bible. And trans people, fun trivia, have library cards, which means that we quickly found out that they were basically just reading off this book. And so decided to, fudge the details when and where we had to, because that was the only way to treatment. And as a result, they decided that the book must be right because every single patient who comes in fits this diagnosis to a T. And so it took an extra 20, 30 years longer than it maybe could have to work out that they were actually misclassifying and misrepresenting a load of people and straight up missing a load of people. Because whenever you design a proxy, a category, a classification, you run into what the late and missed Ian Hacking referred to as looping effects. Having those proxies, those systems, those categories applied to you changes how you move through the world, which also changes, by extension, the population that the category is meant to mirror. So I think there are situations where proxies are the least bad option, but I do think that they are a thing to approach with caution and not, as Kevin and Ari have said, not to be treated as inherently less worrisome than the more visceral seeming data that they're trying to avoid.
Thank you. I think we have one more question.
Hello, I'm Gloria González Fuster. I'm happy to see you again. It's a pleasure to be here and to be discussing gender, data protection, privacy. So I love to discuss gender and data, but I love to discuss data protection law. And I think we can be very critical of data protection law. We can blame the GDPR for everything, data protection law for everything. I understand this, I sympathize with this, but it was quite of ironical, Ari, when you were mentioning like what are the three things that we can do, the three possible solutions. For me, it all sounds like data protection, because you say, let's think about what is the purpose of this. And somebody mentioned purpose limitation. Yes, that's the principle that we have. You collect something for one purpose and you use it for that purpose. Which data are we collecting? That's accuracy principle. You need the data that is necessary for that purpose, that's accurate for that purpose. You cannot change the purpose. Perhaps I was thinking, what's the third principle, the third solution, anti-subordination? Can we call this fairness? Can we put it, perhaps that's the only, I would say the only debatable thing that perhaps is not yet fully covered by our understanding of data protection, but that's my question. Can you save something from data protection law in a way? Do you think those solutions that are at least the principles of data protection that we can reuse or reinvent? Thank you.
Thanks, it's very good to see you in person. So I get that. I see the connections between purpose limitation, data minimization, et cetera. I think about data protection law not as I think about data protection law as I think about all law, not what simply the law on the book says, but how it's actually implemented in practice. And certainly, it's not the be-all and end-all of understanding of data protection law, but just these principles are not implemented in a substantive way in real life. That aside, the third principle of anti-subordination does seem to be the most important of all of those, right? The first two don't work, or they're not helpful unless meant with a substantive addition at the end. Because then you still could get, even with a purpose limitation and data minimization, you can still get an administrative state that's oriented toward efficiency that has no interest in protecting the rights of transgender, nonconforming, and non-binary people. So I'm less optimistic that there's anything that we can save, but I encourage us, I think I encourage that conversation, but because we do want to save something, and I share your desire, but I think it's not enough to say that, oh, this principle, it reminds me of the principle of data minimization or purpose limitation. We have to think about that conversation can't be divorced from how those things are implemented in practice.
Thank you. I was wondering more about, in your latest paper, Ari, you talk a lot about the binarization of data as a mechanism of efficiency. I was wondering if you could speak a little bit to like how that mechanically plays out. Just very high level, talking about that, especially in the context of, we talk a lot about like technocratic systems, like technical systems sort of being like the way we pass this on to, and I guess I'm wondering what sort of role the law plays in that binarization.
Sure, always love a question that lets me talk about a paper that I wrote. Sure, I'll give you two or three very quick examples. With the point being that it almost doesn't matter sometimes how you write a law, going back to this question, it doesn't always matter sometimes how you write a law about gender data collection, because the technocratic systems in place or the techno-social systems in place will binarize it no matter what. So for example, you can write a law that says that as the state of California, my new home, says that if you want a driver's license in the state of California, you have to select your gender, but the options have to be M, F, or X. In the US, X is stand-in for non-binary, and it's a better way, some people argue, than just saying other. And some statutes will allow you to self-identify, so there'll be a blank there. But when that data is shared by the California Department of Motor Vehicles with other agencies in a data pooling agreement, for use in an algorithm for security purposes, the algorithm may only have Boolean variables 1, 0 for M and F. Therefore, it doesn't really matter to in the end, of course it matters to the person who's getting a license, and that's certainly helpful, but in the end, the system, the data collected is binarized because the law of gender data collection forces it into male and female options, which means not only is it binarized, but the people who selected X are then excluded from the rest of the data. Right? Another example of this, pretty similar, is that a statute may require the collection of gender data, but a form that implements that collection based on the statute that didn't say how to collect it, the form then says only M or F. And this happens in 50 states and 51 jurisdictions, including the District of Columbia, 52 including Puerto Rico. All of these states require the collection of sex or gender, have a statute that says you have to collect this information for voting. Half the states require sex or gender data to get a driver's license, and only one state specifically says what the answers have to be like, and that's the state of California. So even though say half the states require gender data, 2/3 of those states create forms written by civil servants that ask for sex, even though the statutes require gender. The opposite is true also. Some states will say you require gender, but then there'll only be M or F. So even if a statute is written that could conceivably be interpreted to allow for self-identification, the forms that are created. And that's another form of law, how it's implemented on the ground, even though civil servants don't have overt power through statutes, they exercise considerable power as they're implementing the law. And there are tons of examples throughout the kind of yellow brick road of the data process.
It speaks a lot to, I think, sort of the discretionary nature of how these systems are implemented. And Oz, you've written extensively about transness and sort of the contextual nature of it, and also how misgendering, addressing someone with gender terms that do not match their identity, can be associated with all sorts of negative health and other negative outcomes. I wonder if you could speak a little bit to how the marking of trans people occurs in data explicitly, and can also amount to this administrative and discretionary violence, if we want to call it that.
I will try and say a few things. My brain is not coming up with much right now. I think it's finally worked out that it's 3 a.m. and that and that I shouldn't be awake. But yeah, so I think that this is both of both Ari's comments and your question are interesting here. I was actually just thinking about a perfect illustration of Ari's point here in my home state of Washington, which is that the law says that there should now be 3 gender markers, and they have actually upgraded all of the paperwork to have 3 gender markers on them. But in some cases, they haven't upgraded the computer systems. And so if you submit a firearms license specifically where you have marked the X marker, then the system will reject it. And so even though there is literally a box on the form for it, and so it will be sent back to you with pick one of the other 2. And what I find interesting about this is that this kind of civil service incompatibility, or slow walking, or not investing as much money in IT, effectively means that it is the people who don't quite fit who then come up for additional scrutiny. Paradoxically, even though the failure is on the administrative side, the scrutiny that is applied as a result of the failure applies to the person who highlighted that the problem was there, rather than the person who is actually responsible for the problem. And I guess I'm saying this to introduce this question of, what are the consequences of those incompatibilities? What are the consequences of this kind of administrative misgendering? And I mean, they're pretty extensive. The obvious and most immediate material, visceral ones that people can imagine are, I think, around things like policing and the carceral state, right? Which prison you end up in matters. But particularly in the US, although not exclusively, it also matters, for example, what the array of forms that you fill out for healthcare look like, or how airline travel handles incompatible pieces of administrative paperwork. With healthcare, you might have an ID from a state that has one idea of what gender is, and then an insurer that has a different idea of what gender is, and then a federal standard that has a third idea of what gender is, mediated by an electronic medical record system that has a fourth, and is somehow expected to make the three line up. With airline travel, I approach this as someone who is in a weird spot. I'm not a US citizen. I am a resident of the state of Washington, which has 3 gender markers. I come from a country which does not have 3 gender markers, and so to travel internationally, I need my green card, which has 1 name and 1 gender marker, my passport, which has a different name and the same gender marker, and my state ID, which has a different name and a different gender marker. And every time I deal with air travel or airports or anything else, I wait for the moment when I will get stuck in a small room and left for 3 hours until they come in and explain that the paperwork didn't match, and that it somehow took them 3 hours to simply ask me why the paperwork didn't match, or if I have a change of a certified notarized copy of the change of name documentation in my pocket because I have to carry it everywhere with me now. And I do that because it's happened multiple times before, and it is far, far, far worse for people who are already subject to scrutiny because they are already, they are making the terrible mistake of not only traveling and existing in public while trans, but also doing so while a person of color, while poor, while suspicious, while Muslim. The fact of the matter is that in many cases, I am the luckiest of all of the people dealing with this kind of administrative capability, right? I am I have residency in 2 countries, one of which is the country that gets ornery about these forms, and the other of which gave me an accent that is, thanks to colonialism, universally interpreted as worthy of, if not respecting, then at least listening to. I am so white my tattoo artist uses my skin for white ink. And I still get stuck in small rooms in Minneapolis airport on a regular basis whenever I leave the country, regardless of the paperwork I bring with me. So doing that, and then as a result, having to not only negotiate with the semi-armed pizza box recruited immigration and customs enforcement agents, but also articulate your gender to them in a way that is compatible with their worldviews, knowing the politics of US law enforcement and where they tend to fall on the spectrum, and knowing how much they tend to give a toss about actually following the rules of civil society. I'm a smoker who doesn't like crowds. I already hated airports, but this has made it so much more dramatically worse. And yeah, I'll stop, I guess, rambling on this at this point, aside from simply say that the reason I highlight all those stressors, all those tensions, the fact that they are in interaction with armed members of the government at a point in space and time where, according to the US court system, the Bill of Rights does not apply. If you're going through immigration, you do not have rights. It is a purely administrative process, is to say that all of it is deeply fraught and deeply violent. And it's brought on, in part by this deep incompatibility between systems, but really it's brought on by the fact that we have decided all of these different levels of government that this thing is something that we should administratively care about, even when we can't articulate what use it's actually for. And then the people who do not fit should be the ones to deal with the consequences.
Thank you very much. Thank you. Could you please give a round of applause for our panelists today?
And for Nasser.
I won't keep you from lunch, so thanks so much for attending. Appreciate it. Have a good rest of your day.